So this is a really general overview of how to approach an exam. I'm not sure that I've done something like this before, although a lot of this has been at least implicitly set out in some of the answer keys that I've had for some of the hypos. Uh, but I want to be more explicit about it. And I think this gives you a pretty explicit framework for how to take apart any issue that you spot. So what I want to do is review kind of answer planning and then get into answer structure and line by line analysis. And all of this is pretty new material. Going back a little bit. So remember, last week we talked a little bit about answer planning. That is, you're not going to just grab your exam and start typing right away. You want to spend a quarter to a third of your time actually carefully, deliberately planning out your answer and reading the exam multiple times. And as I said before, on the first pass, you kind of do an initial read, you don't write, you read through the facts and get down to the call of the question or the issue to understand what it is that you're being asked. On a second pass, you do what I call light bulb style issue spotting, whereas whatever pops in your head as you read a second time, you begin to scribble down as notes, sort of basically brainstorming. On the third pass, if you have an open book exam, you use your outline, maybe you flip your outline for more ideas and you engage in a little more deliberate issue spotting. On a fourth pass, or maybe you don't read it again, you begin to kind of arrange your answer in outline form, and I have some tips on that. And it's on the fifth pass that we're after the 25 or 30%, and that you actually write out your answer using the kind of structure that I'm about to show you. So there's something that I ask you to do on hypos and something that's slightly different than exams. But the reason that I ask you to do, or at least I create incentives by points to write answers in a certain way on hypos, is to get into certain frames of mind, ways that you continue to think even as you stop writing them. So in training in a lot of the early hypos, I ask you to do full IRAC, or what I'm going to now call a TRAC analysis. So I'm going to go over that very quickly. The bulk of what I'm about to say is the analysis part. IRAC is not much of a framework because, to me, the issue, rule, and conclusion are relatively simple things. I'll get into that in a second. It's the analysis itself that is like 90% of it, and itself is quite complex. But all of that is kind of training. So the structures that I'm going to show you here that you'll probably recognize from the answer keys that I've set out are training. When you actually get into combat, I've for some reason been rewatching Band of Brothers recently, you want to fall back on a mini IRAC. This kind of stuff is in the way that you mentally attack a problem, but you don't need to say all of it for a full exam, and in fact, it may slow you down a bit. So let's get into each component of these. IRAC, again, most professors and kind of bar exam teachers teach IRAC, but I don't think they really tell you in very helpful detail what you do. So this itself is not super detailed other than analysis, but I think that there's not much that has to be said here. The issue is something that you formulate clearly, and some of it kind of assumes knowledge of the rest. So you'll have people like Wentworth Miller in his LEEWS system that says don't even state issue. So for me, I'm not a stickler for citing the issue, but sometimes it can be, it's a little weird and transitionalist just to start talking about the rule. And I think there's a better way to do this. But if you're going to state an issue, state it clearly. There's a very particular way to do that. You have to ask a question in a full, using nouns and verbs, but the formulation of the issue isn't just some act or reference to did X commit some law. It's kind of almost a summary of the facts and the law that are at play. So if you go back to the Brazilian pies hypo, which is only a battery issue, where people go up to booths that have this mysterious hole in it, and most of you, I think, have taken it at this point, and get a pie thrown in their face. One of the booths says look, and the other one says don't look. So in the case of don't look, the way you would frame the issue is, does DLC's throwing of a pie, preferably at pH, I should have written here, does that equal battery? Does that constitute battery? This should be a full sentence. If you're not kind of doing both, you're not really stating an issue. It's not just did DLC commit battery. In the context of a hypo with just one set of facts and one law to apply, it seems like you don't need to say more. But in the context of a lot of facts, a lot of different torts potentially happening, a lot of acts, and a lot of different legal claims at issue, it's not good enough just to say, did this equal battery? Did he commit battery? You have to mention the person, the act, and the potential claim in the issue. Okay? Then you state the rule. The law of battery is ... And the only real advice I have for you here in restating the rule is not to paraphrase. It's something that I see a decent amount in exams, and hypos that I've looked at, and you get no benefit from trying to, there's a thought underlying paraphrasing the rule, which is trying to show the professor, hey, I get this law, I get the law, I can rephrase it and put it in my own words. Don't do that. Use the actual phraseology that the professor himself has set out in class, if he set it out at all. If not, try to follow what the closest case that you've read sets out. Failing that, what's set out in a commercial outline. Analysis is the separate and the bulkiest section to come. And a conclusion, a surprising number of people seem to leave this off of their hypos, even those that I've looked at relatively recently. And I think there's a fear, there's both a fear of saying something that's wrong, and perhaps it's the emphasis that I've placed on most of your points coming from creative analysis. But you do need to come to a conclusion. Again, if you think back to what it is that you're doing on an issue spotting exam, it's not unlike consulting a client who wants to know, would I prevail if I sue? Your client's not necessarily interested in the rest of this for its own sake. Your client wants to know the bottom line. Now, that doesn't mean blindly saying you'll win or you're not. The law is probabilistic, and so this is where I've suggested that you use that phraseology like the better view is ... And I think that works well on exams. Now, that's usually if it's at least if there's a decent argument on either side. If it's a very clear case, then say that. But in many instances, you'll get something that's at least somewhat ambiguous, and so you might want to use that kind of phraseology. So that's IRAC. If this is too much work, there's a little bit of a lighter lift than setting this out in a sentence, because sometimes it can be confusing to know what the fact is that you slip in here. That's perhaps somewhat clear in the case of a tort, but in other subjects, maybe it's not so clear what you say here. So to do away with the pain of having to find the right verb, there's TRAC. It's like IRAC, but instead you replace the I and you get a T for the title, so that you basically write the issue out in a shorthand without any verbs. You just kind of set out the parties or the party and the act committed by someone and the legal claim. So This is what you can write kind of in full at the top of a paragraph of analysis. Just remember, this is back to the Brazilian pies example. The pie haters versus the don't look crowd, thrown pie equals battery. That suffices to actually set out the issue. And since maybe that's the only place you're not going to speak in actual nouns and verbs like grown adult, the professor will forgive it, but the professor will know exactly what you're talking about if you say this and you follow it with good quality analysis. It also minimizes your desire to kind of fill this with filler words. This is quite concise and will do the job in identifying the issue, then you can move on to the rule. Now, let's turn to analysis. And there's a decent amount I have to say about that. A lot of this is by way of example. If you use, this is still going back to the Brazilian pies hypo, but you want to structure your analysis really, really systematically. The creativity that I've talked to you about in the past is at the line level. But the overall structure, you don't need to be very creative about at all. For each element of battery, you want to have this issue set out here, intent to commit battery. You start with the plaintiff's argument because the plaintiff has the burden of proving, I mean, he's the one who's suing, so he's got to go first to set out his affirmative case, the prima facie case. And so you're this systematic. You start with intent. Within intent, you start with the plaintiff's argument. Here it's pie haters on intent. Pies don't throw themselves. The sign said, don't look here, but this was some attempt at reverse psychology to draw somebody in just so that they could be in range to throw a pie at, blah, 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 blah. So this is where you're kind of developing the argument. On plaintiff's behalf, then you turn to the defendant's argument. You know, the sign clearly said, don't look here. So we were trying to dissuade people from walking up to the booth, and anyone who came up to the booth, well, then that begins to fall within consent. And then you come to a conclusion on this issue. What you do not do, I'm trying to find a place to set this out. You do not set out the plaintiff's arguments as to each element and then the defendant's. It's very hard to follow because the argument takes place at this level. For an analysis of elements, the plaintiff has to prevail on each and every element to prevail on the claim. So you want to know early on if a plaintiff fails on any one of these. And if you go through the entire analysis as to each of the elements by rote, it will be mechanical, but not in a good way. You may be able to avoid analysis on some issues where it's easy, and it's hard to go back and forth when you're spread out, when you set out intent, then offense, offensive, and then touching, and then without consent. If you lay those four out and then go to the defendants, and then if you have rebuttal arguments, the structure gets quite muddled quite quickly. So this is how you want to set up each thing. You've got your element, and all the argumentation as to that element takes place right away. Okay, that's intent. Then offensive. PH argument on offensive is set out. Nobody likes getting a pie in the face. It's not where pie belongs. Pie belongs in tummies. It's not like a hug or some other thing, which even in depending on the context could be offensive, but there's almost nothing inherently good about a pie in the face. Don't look, DLC's argument on offensive is that it's not like being punched or spat on. Your conclusion might be that the better argument's probably clearly pi haters. I mean, one of the things, if you watch a cartoon or even some random YouTube videos, one of the highest class ways of humiliating someone is to throw a pie in their face, a cream pie in somebody's face. So you've set that out. All of the argumentation as to this element takes place here, and you resolve it. On touching, you at least can mentally go through this. But in the Brazilian pie type, there's really there's no good argument on DLC's behalf that no attention, and this is a typo here, all this should say touching. There's no realistic argument that DLC can make that a touching did not take place. Even offensive as to whether or not getting a pie thrown in the face is kind of offensive is an iffy thing to argue against. But here you can't even argue touching. If you did a full, if you didn't settle each argument within each element as you went along, you couldn't just take care of this issue very quickly. You'd have to run through, you'd end up running through and talking about, well, pH can prove intent and offense, and then there was a touching, which is pretty obvious, and then you'd still have to go through, when you run through all of DLC's arguments, if you're not following the structure and you take the party and all of the elements in that order, you're going over touching when there's no reason to go over this. So mentally, this is what you're thinking, but even in a full IRAC analysis, you might just settle this very quickly and say there's no question that DLC's pi made contact with pH's face and just move on. And I'm only using the hypo as an example, but it is interesting to note, as I said last week with Brazilian pies, that the main thing that was of interest to me was whether or not there was consent to get a pie thrown in the face. Whether the sign says look or don't look, the person affirmatively goes up and looks in this hole and gets a pie thrown in the face. So again, you follow that analysis. You still follow this. And on a tough issue like this, and you'll see from the answer key that I've put up for Brazilian pies, you might not just go through one cycle of argument. You'll set out pH's argument, or it may be hard to say a bunch of things without going back and forth. So pH has an argument, then DLC has an argument, then pH has a counter argument, then DLC has a counter argument. It's very hard to go back and forth like that if you go by party, all the elements, other party, all the elements. So that's why we've got the consent element. We can settle everything under this block. It'll be its own paragraph. And that's it. So that's when the kind of analysis ends, and then you return to the overall conclusion from the C part of IRAC. So you can draw an imaginary line here, and I can draw a not imaginary line for you. This is analysis, so you've got the I and the R somewhere, and this is your conclusion. But you can see that analysis was the bulk of everything that's happened. You've got a single line for the issue, you've got a quick restatement of the rule, you've got a bunch of things going on for analysis, and then you've got a conclusion. And this is what I was mentioning before. This manner of argumentation permits you to engage in counter argumentation so that you get to very deep levels of analysis in a structure that will be easier to follow. I can stop there. I want to maybe stop there for questions if you guys have any before going on to mini IRAC or TRAC. If you have a question, you can do, there's a way to digitally raise your hand, or you can just kind of type the question out in the group chat and I'll read it and we can discuss that question. So I'll stop there for a couple seconds while I have a sip of decaf coffee. I'll try to mute so I don't make a slurping noise, but I'll leave it there for a minute for questions. I'm going to move on if there are no questions about that full analysis. So on mini IRAC, you have this issue. Maybe you can start the first. Let me back up even further. On a crim, or especially a crim and a torts exam, you can have a large litany of really random facts that you have to go through relatively fast. So if you can do a full IRAC, that's great. Sometimes professors don't score exams necessarily as I set out the scores for hypos. They can be more condensed, and they may not give points for setting out the rule or doing this or that. They may focus much more purely on the substance. Nevertheless, the reason that I allocate points for those is those are habits of mind that will ultimately let you find the substance to actually engage in deeper analysis so that you can get more points. Still, writing out the full IRAC might be too time consuming, and you want to catch as many issues as you can. You may have to move a little bit faster, so you can end up, especially where there are a lot of easier issues, or even if there's some ambiguity, you've got like a 70 or 80% feel that an issue cuts in one way on a particular element, that the argument goes more clearly to one side or the other, you can set that out relatively clearly and quickly. But this mental process of going through a full IRAC, that stops you from jumping to stupid conclusions, because if you have this mental discipline of at least trying to come up with arguments on both sides and taking both sides seriously, you are much less likely to miss stuff. So you never lose this habit, but that habit stays in here, and maybe not all of it ends up on paper. So as I just went over in the Brazilian pies hypo, the touching, the other things that are under dispute, but the touching you would not waste time doing a back and forth on. You just say a little dispute here that the DLC touched pH with a pie. And you might even do that with offensive. There's a little more wiggle room to argue offensive, but you could probably more clearly say most people think a pie in the face is offensive and just move on. Okay. I wanted to talk about the different ways of reasoning. This is just the start of a list of kind of general categories of tools that you have when you engage in this line level analysis. What is the style of argumentation? How is it exactly that pie haters is applying the facts to the issue of not giving consent? And so there are different techniques. This is not at all exclusive, and I'm going to probably work next time on a very long list of these so that you can kind of cycle through them as you work. The first one is you can argue by direct application of a rule of general application, which is something that I've discussed before. That's what you want to extract from a case that you read. But if there's a case, basically all I'm saying here is that if there's a case that's directly on point, one that's not one that just sets up the general elements, but is an application of the law in one of those instances, then you can kind of stick it right here. So you've got like the eggshell skull case. If if the Brazilians pies hypo had been a little bit different, someone gets a pie in the face and goes into anaphylactic shock because it's a banana cream pie, and that person is allergic to bananas. That's actually something between here and here, but it's a bit closer to the direct application of a rule of general application. You throw a unwanted pie in someone's face, you're responsible for all the consequences. You take your victim as they are, not, you don't get to judge them against the standard of a non-banana allergic person. The next step, and what most of you do most of the time, I think, once you're given some cases, some RGAs, is there are situations where you don't have something that's dead on like that, but that you are kind of arguing a little bit more by analogy. Now that assumes that you have some kind of case on point. Most of the hypos I give you leave it pretty open so that you don't have a lot of case law that tells you what goes on. Sometimes I put in a little note 1, note 2, note 3. But you can argue by analogy if you think that there's a case that helps you. If you don't have a case that helps you, what you sometimes end up doing, and I think this is often what a lot of you have to do in the hypos as I've set them out, is to argue by the absence of facts. So in the instance of offensive, in a way, both sides are kind of arguing from what this situation is not. So if you're trying to build an affirmative case, the pie haters as plaintiffs would argue, well, pie in the face is not like a hug. It's not like a light touch it's not like a pat on the back. It's not, there are other manners of touching that even if they're unwanted are not inherently, offensive. But you had to kind of pull these other examples. There's no reference to hugs or pats on the back in the fact pattern itself. It's you using your experience and, in a way, common sense to kind of develop the absence of certain facts to prove your point. Then on the other hand, don't look, we'll say, well, a pie in the face is not like punching someone in the face or hitting them with your car, not kicking their cane. And so there's something between, they're also, that guy's sort of arguing by analogy in that instance. But he's also citing this litany of things. This situation is not like other situations. So in a way, these are kind of flip sides. There's something positive to follow, and this is the absence of other things. But sometimes it's not even case law. It's a reference to real life facts or your experience, such as would be relevant on this. You can also build on these things by arguing by way of factual inference. I've done videos on this, but it's kind of one of these where there's smoke, there's fire. So an example of this is, in the videos, you never see the people throwing the pies, and yet you kind of infer intent by factual inference, because pies don't throw themselves unless there's there's no evidence that there's kind of a pie throwing machine. But that's in a way how you build your case for intent as the pie haters in inference. You don't have the fact itself. You don't know the mental state of the people who threw the pies, but just watching the fact that these people had pies thrown in their face, pies are not thrown by accident. Maybe common sense is some other version of that. And sometimes you can kind of argue things by the ultimate policy purpose of the law that's set out to deal with them. There's not a clear example of that in the instance of Brazilians and pies, but in other instances where you would refer to the compensatory purpose of tort law, that it's not like crim law in the sense that you're trying to allocate moral culpability, but it's a question of somebody was hurt in an accident, who pays? And that can often be used to kind of cut through harder issues, at least in the context of torts. Finally, you can use any combination of the above. You can mix and match these as they help you argue specific sides of a specific element using certain facts.